Sir Isaac, we're privileged here in the year 1947, which I'd chosen being the date of my birth, and only a couple of years before your sad passing, to conduct this review of your life. The wonders of modern science have enabled us to bring you back to life, larger than ever, and to record this. Welcome to this event.
Perhaps a little taller.
A little taller. Just to remind the people here about the great man that we do have in our midst, you prepared an entry for the 1947 Who's Who in Australia, believed to be the only time you've recorded your own life history in brief, and just to mention it, you describe yourself as the Right Honourable Sir Isaac Alfred Isaacs, GCB, created 1937, GCMG, Knight Commander of the Order of St Michael and St George, created 1932, the only surviving member of the Federal Convention, 1897-8, the first Australian-born Governor-General of the Commonwealth, son of the late Alfred and Rebecca Isaacs, Auburn, Victoria. You were born in 1855 in Melbourne, educated at the University of Melbourne. You worked in the Victorian Education Department for a period, called to the bar in 1880, Queen's Counsel, 1899. You became a member of the Legislative Assembly of Victoria in 1892. You served as Solicitor General, then as Attorney General for Victoria. You were a member of the Federal Convention in the 1890s. You entered federal politics in 1901. Became Attorney General of Australia 1904-6, a Justice of the High Court in 1906, where you served until 1930 as a single justice. You were a member became a Privy Councillor. You were Acting Chief Justice. You became Chief Justice in 1930, shortly before you were appointed Australia's the first Australian-born Governor-General of the Commonwealth. You ceased to hold that office in 1936. You were a bencher of the Inner Temple, and there were various other awards. Your recreations are listed as walking and reading. A very full life, Sir Isaacs.
Yes, I think you've summarised accurately. I'm sorry, I didn't wear my medals. I thought this was an informal occasion. I no longer have the cocked hat I wore as Governor-General. And of course, the full-bottomed wig that I wore as Chief Justice, when I left the court, I donated that to the Speaker of the House of Representatives, who I believe still wears it.
Can you tell us a little bit about your childhood, your upbringing, and your relationship with your mother?
Well, it was all my relationship with my mother. She was a marvellous woman. She shaped our lives, you know. It was she who decided that she and my father should move to Australia. It was she who moved us to Beechworth when my schooling required us. She taught me everything I knew. She had a marvellous memory. She could recite pages and pages of Dickens from memory. A wonderful gift which I was fortunate enough to inherit.
We are fortunate that some of your correspondence with your mother was preserved, as many other memorabilia of your life. You had a very close relationship with your mother even throughout your adulthood.
Even when I was on the High Court, I spoke to her every day. Every day. I never missed a day.
And you would write to her, and you wrote to her as your dear, darling mammy?
And she wrote to me as her popsy pet. Even when I was on the High Court. She died, you know, in 1912. Yes. Very sad.
She predeceased your father?
Yes.
Yes. I'd like to pick up on on one event for which you are remembered, your role in the 1893 prosecution in the Mercantile bank case. Perhaps if you'd like to tell us from your perspective what happened, and I might then ask you one or two questions.
Well, it was a very sordid affair. The bank had failed. You must remember this was a time in Melbourne when many banks were failing. It was a period of, if not global, certainly a financial crisis. And the bank had failed. The chairman and the head of directors had absconded. The chairman had close political connections. He had previously been a member of the Legislative Assembly. The government refused to prosecute him for fraud. The Attorney General refused to prosecute, but I was Solicitor General, and of course I had an independent discretion, so I announced that I would prosecute.
And, well, can I just... I hesitate to challenge such a great man, but you were a member of cabinet at the time. What right did you have to break with cabinet solidarity?
Well, the role of Solicitor General was evolving. It was true that I was a politician and a member of cabinet, but under the Crimes Act I had an independent authority to prosecute, and it was my duty to pursue that in the public interest. It was my colleague, the Attorney General, who was bowing to base political considerations. I stood independently of politics. I did my duty to the people of Victoria.
Was it not possible that while you had a right to initiate the prosecution, he had a superior right to you to decide whether or not it would go ahead?
Oh, this sort of pettifogging bureaucratic argument was used at the time, but the statute was perfectly clear. He had the power to prosecute, and so did I. I had an independent discretion, which I exercised, as I always did, in the interests of the people.
Well, I suggest your memory just slightly remiss, Sir Isaac, in that you threatened to exercise it, but you were tapped on the shoulder and forced to resign.
Indeed, I was forced to resign, but I immediately stood for re-election. And I was re-elected overwhelmingly. That shows you what the people of Victoria thought of the affair.
Do you... So in this, and perhaps we'll see there are other areas, Sir Isaac, you take no backward step or concession of error, notwithstanding the view of other scholars in this field.
I never fell into error. It was always perfectly plain. You analyse the situation, you bear in mind one's duty to the public, and one acts accordingly. Always a question of duty, simple duty.
Your biographer, I think he gathered the information, he's still gathering the information, and his book was published after your death, Zelman Cowen, your successor as Governor-General of Australia.
Yes, I believe he was at Melbourne Law School when I knew him.
Sir Owen Dixon told him that this 1893 episode gave a key to understanding yourself. It led to your resignation from your first public office, and from that time onward you were distrusted by your peers. Was that a harsh judgment by Sir Owen, and what did you think of it?
Oh, I think it's rather harsh on some of them, though they were always quite courteous. It's true that I was under considerable political pressure, and that in that situation I adhered to what I knew to be my duty. You might say that that formed my character, but I believe that always had been my character. I had learnt my duties from my mother.
In the 1890s, you attended the convention, at least the later conventions. I cannot recall whether it was all of the conventions.
Not in 1891, of course. I was not in politics.
Not in politics then. And you played a significant part. What is your memory?
Not significant enough. I should have been on the drafting committee.
Yes.
Yes, the Constitution might have been much better had I been permitted to play that role, but it was not to be.
What were some of the matters in debate that you were particularly concerned with?
Well, I suppose they were chiefly drafting matters. The drafting committee, in many ways, didn't do a very good job. Barton, you know, was not really up to the job in some ways. On matters of principle, the referendum, I was strongly in favour of the referendum, and we were able to get it into the Constitution, but when I was Attorney General later, we were able to amend the Constitution to strengthen the referendum procedures, which I would have done in the first place. The other matter was the deadlocks between the two houses. There were those bent on giving much too much power to the Senate. The principles of responsible government were fundamental to the Constitution, and they absolutely meant that the lower house, being the popularly elected house, must control the ultimate decisions of the government.
What did you think about the guidance that could be drawn from the American constitutional experience?
Oh, as I said repeatedly, and I said this at the convention, and I said it as Attorney General, and I said it at the bar, and of course I said it in the engineer's case. The American Constitution was entirely irrelevant. We had two great blessings that benighted country does not have. We had the indivisibility of the British Crown and the institution of responsible government.
There was a provision inserted into the Constitution, expressed very simply, a little bit of layman's language as one of the delegates put it, that became Section 92.
Oh, I certainly contested that piece of sloppy drafting. I insisted that it was no good to say absolutely free, one must say freedom from what? What I proposed to the convention was that it should say freedom from taxation and restrictions.
And my reading of the debate says you proposed it more than once and made, dare I say it, almost a nuisance of yourself in pushing that view.
I believe there may have been those who took that view, but they were quite wrong, of course, quite wrong. As I said in the convention, I had no objection to interjections, even repeated interjections, provided they were in pursuit of a better view of the Constitution, and all of my interjections were of that kind.
Well, maybe we might at this stage jump through and see what happened in relation to Section 92. I'll return to other earlier aspects of your judicial career, but did the promise of the provision come to fruition during your judicial career?
Well, yes, during most of my judicial career it did. You must remember that although I was on the court from 1906 onwards, my period of greatest influence began in 1920, once Sir Samuel Griffith was gone. Sir Adrian Knox was Chief Justice, but I was the senior puisne judge, and it's fair to say that during the 1920s, my views prevailed on the court. As to Section 92, from 1915 on, I had taken a proper view of the application of the section, but it was in 1920 that I persuaded the court of the very simple view that Section 92 binds the states but does not bind the Commonwealth. And right through the 20s that view prevailed, along with the logical interpretation of the words of the Constitution itself. And as to the Commonwealth not being bound, well, that prevailed until 1936, when it was overturned by the Privy Council, a clear case of palpable error.
Did you not write or publish something about the Privy Council's error?
I did. In 1939, I wrote a pamphlet on the topic. Palpable error were the very words I used. But of course, what could you expect from the Privy Council? Way back at the time of Federation, I had pointed out that those English gentlemen sitting in their dingy den in Downing Street, they had no more chance of understanding the Australian Constitution than if they'd been gentlemen from Mars.
You did accept office as a Privy Councillor, Sir Isaac. Did you sit on the Privy Council on occasions?
There was. I'm not sure. I'm not sure. I certainly advocated that if the Privy Council were to be improved, it should be composed of senior judges from the Commonwealth. I think you told me young Barwick took that view later, but I took that view. I told Winston Churchill that that should happen back in 1920.
When you came to the High Court in 1906, there was the old guard of Sir Samuel Griffith and Justices Barton and O'Connor, and you and Justice Higgins, both Victorians, arrived in 1906. What was there? Did you feel that you wish you'd been there at the beginning? Had the High Court got into good or bad ways by the time you'd arrived?
Well, not too much damage had been done, but it was certainly true that in the beginning, Higgins and I found ourselves in repeated dissent. The great issue was what I already mentioned, the engineers case. The Griffith Court had taken the view that Commonwealth legislative powers could not extend to binding the states, and in particular that the Conciliation and Arbitration Act could not bind the states. Now, it's true that when I was in Parliament in 1904, when the Conciliation and Arbitration Act was introduced, I had my doubts about how far it should extend to the states. In the end, it was made to extend to state railway servants, but there was much debate about it, and I did at one stage take the view that the Parliament of Victoria had made proper provision for its own state employees, and that the Commonwealth legislation should not interfere with that. But that was my view at the time as a matter of policy. As a matter of constitutional law, Barton at that time took the view that extending the Act to the states was unconstitutional, and I never took that view. I always differed from him on the constitutional point. Now, it was true that at the bar, in Deakin and Webb and Webb and Outram, I had to argue the case for Victoria, and in that situation I accepted my brief and I argued the case for Victoria. But certainly from the moment that Higgins and I joined the court, we were firmly opposed to the Griffith view that that act did not apply to the states.
And it took, of course, quite a time before it was overturned. How did it come about that the High Court eventually switched, and what actually happened? What's your memory of the engineers case and how it was all conducted?
Well, it had been coming for some time. It was the numbers had been gradually changing on the court. Young George Rich had arrived in 1913, 1914, and of course he immediately agreed with me on every point. Later on, I believe, after I was gone, I believe he regularly agreed with young Owen Dixon. A charming man, but perhaps not given to independence of thought. So he agreed with me. Powers was there. Higgins had always agreed with me. So the numbers were changing. Finally, in 1919, first Griffith went and then Barton went, and there was a new Chief Justice, and only Gavin Duffy dissented in the end. Mind you, the case need not have been decided on that point at all. Higgins and I had already established that the so-called doctrine of implied immunities only applied to governmental functions, so that the Melbourne City Council, for example, was not protected. This was a case about the Western Australian sawmills, It would have been perfectly easy to decide the case on the ground that running a sawmill was not an inherently governmental function. But young Menzies was persuaded to take the broader ground. I think that was a case where it was already clear the view that a majority of us would take. Stark was there by that time. He agreed with us in that view. Powers, Rich, as I say, even Knox, mind you, Knox was a slight fellow, personally charming, always very courteous to me, but always more interested in horse racing than in constitutional law.
And he left the court because he'd been left some money in a estate. Is that
John
right?
Brown, the coal baron, John Brown, yes. Knox retired from the court to administer his estate. And that was when I became Chief Justice, but of course I didn't last in that role very long.
Yes. Now, Sir Owen Dixon, who we've mentioned already, came on the court in the 1920s, and as you know, as you look back from the time after you retired from the court, there were a number of qualifications added to the doctrine of the engineers case. Were these a disappointment or a surprise to you? Or?
Well, not actually. As I've said, even in 1904, it was a difficult policy issue. What young Dixon did in a series of cases building up to round about now, it's just now in 1947 that he decides the Melbourne Corporation case. But he had built up to that by picking out things that I had said in the engineer, and of course it's no secret that I wrote the engineer's judgment.
It has your style about it, Sir Isaac.
I think I could say that I expressed my views firmly, yes.
Yes.
But in the course of that judgment, I did say that the prevailing doctrine of government, central government power, would not necessarily apply to a discriminatory law, would not necessarily apply where the royal prerogative was affected, would not necessarily apply to particular kinds of laws such as taxation laws. And all that Owen Dixon did was to pick out those 3 points that I'd made very clearly in the judgment and build his proposed exceptions on those. Well, I had said it all along.
One thing you said, from my recollection in engineers, was the principle of the indivisibility of the Crown, which I think you've already said today it was dear to your heart. How can this doctrine have any meaning in an Australian context where you have states and states fighting against each other, the Commonwealth and the state litigating?
That's exactly the point. That's exactly the point. There may be to-ing and fro-ing at the political level, but they are united. Australia is one country. We are united Australians. And what unites us is the indivisibility of the Crown. Yes, there is the Crown in right of New South Wales, Crown in right of Victoria, Crown in right of the Commonwealth, but all of these are only manifestations of the one and indivisible Crown.
Yes.
And this is why the American doctrine of state immunities made no sense at all in Australia. Because if Arizona is an independent sovereign state, then it may be that for federal laws to apply is incompatible with their sovereignty. But if the sovereignty of New South Wales and the sovereignty of the Commonwealth are merely manifestations of the one and indivisible Crown, then there's no conflict. The whole doctrine disappears.
Sir Isaac, when you came to the High Court, some of your colleagues, Sir Samuel Griffith in particular, wrote letters, which we now have access to, in which they resented you, were angry about you. You were described as a dueling. Were you aware of hostility, personal hostility, and anti-Semitic hostility?
I don't believe so. Griffith in particular was a man of strong opinions, as I suppose it could be said I was. We both expressed ourselves firmly in the cut and thrust of debate. Each of us sometimes said of the other that he was advancing an opinion which it was impossible to view with gravity. Yeah. This was the ordinary rhetoric of the day. You mustn't read anything into that. Barton in particular was always so courteous, so gracious to me.
Yes. The style of angry denunciation within a court, whereby the dissentient accuses the majority of idiocy or worse, was quite marked during your period and seemed to disappear, at least for a period, in the High Court. Maybe it will come back again in later periods after 1947.
It's true that we were, on the whole, a very happy court during the 1920s. Gavin Duffy took a different view from the rest of us of the Conciliation and Arbitration Act. Gavin Duffy was much too prone to take the view of the states. Knox, I'm afraid, sometimes agreed with him. But apart from that, we were a harmonious court. After I'd left the court, of course, things were very far from harmonious with Everett and Stark. I mean, Everett and Stark wouldn't talk to each other. Even in the Griffith day, we were always courteous to each other in public.
Just perhaps give us a little bit of an idea of what life was like on the court. The court sat. Did it have a principal seat in Melbourne?
The principal seat was in Melbourne, but we sat in every capital city, as we should. I mean, it's very important that this is a united country. We Australians are one people, and it was important that the court of that country should appear in every state capital, and we did. We had some very tedious train journeys, and some even more tedious boat journeys across Bass Strait, but it was all right, it was all right.
The volume of work was not very significant?
Judicial work is always significant, burdensome. Writing a judgment is never an easy task, even when one knows the conclusion in advance. But compared with the time in 1904, 1905, when I was at the bar, but also Victorian Attorney General, and I would work at the bar all day and then go and do the attorney's work all night. That was overload for you, that was work.
For a man who just strikes this observer as having quite firm views on most things, your judgments were very lengthy. For example, in the Colvend case, which you tried at first instance, your judgment was 270 pages of the Commonwealth Law Reports. I perhaps shouldn't, but I will mention the full High Court took only 31 pages to reverse you.
Yes, but you must remember that mine was the judgment of the trial judge, and I had to review the evidence, and I had to make findings on the evidence. It was a very complex case. It involved that same fellow, John Brown, who was later such a friend of Adrian Knox. The coal mining companies in New South Wales were engaged in very corrupt practices. It was the great test of the Australian Industries Preservation Act, an act which I had fought for even before Federation, an act which you asked about, the Griffith Court. Now here was a mistake. The Griffith Court struck down the Australian Industries Preservation Act in the case of Huddart, Parker and Moorhead. I dissented in that case, of course, as did Higgins. But it's a great pity that the Australian Industries Preservation Act has never been able to operate effectively since. In the Colvin case, I made very sure that it did operate effectively. It's a pity that the Act was... I think you mentioned to me that sometime after my demise, the Act was revived.
Yes, the High Court changed its view.
You see, in the long run, the correct view always prevails.
We haven't got time to talk about what happened to Section 92, but the ultimate view that occurred may not have been that far from the one that you were espousing.
Well, during the 1930s, I watched Owen Dixon dissenting in those 92 cases, and he adhered very closely to my view, very closely. And I must say that at the time he seemed to me like a prophet in the wilderness, seeking in vain to return the court to the words of the Constitution. But again, I think you told me that indeed, in 1954, Dixon's view prevailed, and once again, yes, justice was done.
For a time.
For a time.
We haven't got time to go into that one. Your judgment writing style was rather distinctive at times, Sir Isaac. Your biographer particularly remembers a case in which you launched into flights of hyperbole about the meaning of a sausage.
You say that as if there's an element of absurdity in it, but as I said at the beginning of that judgment, that was one of the very most important cases that the court ever had to decide. It affected the health, nay, the life, of a very large population of the citizens of New South Wales. The question was about the health and safety of sausages, a very important question.
Well, you were particularly disappointed that your view was a minority one in that case.
Well, the question was whether a sausage fell within the statutory definition of a carcass or a part of a carcass, and my answer was that of course it is part of a carcass, just as a cricketer is still a gentleman when he puts on his flannels.
Yes, your words that a sausage in its skin remained meat just as much as the identity of a man remains whether he's called a soldier in uniform, a barrister in robes, or a cricketer in flannels.
Exactly. What could be clearer than that?
You would have seen young Dixon arguing cases during your time. Was his position, reputation, and skill as an advocate indicative of the fact that he would become one of your successors as Chief Justice?
No doubt he was an outstanding advocate, outstanding. Very keen sense of precedent, very keen eye for the logic of a judgment. I did watch him through the 30s and into the 40s. Very capable judge, very capable. Certainly on the analytical, on the logical side, you couldn't fault him. I think perhaps if he had a fault, he didn't sufficiently appreciate the underlying national purpose of the law. A little narrow perhaps now and then. But a very fine judge, very fine.
In 1930, as you've indicated, you became Chief Justice for a short period, and then you were appointed Governor-General of Australia. Now, this was quite controversial. What was your understanding of the controversy that surrounded your appointment?
The main objections, and they were totally spurious objections, the main objection was that appointing an Australian Governor-General would somehow weaken our links with the British Empire. Now, this was nonsense. as I pointed out many times, being proud of one's Australian nationality is perfectly compatible with loyalty to the Crown and the Empire. We are proud and privileged to be part of that empire. And I performed that role. It didn't matter from that point of view that I was an Australian. We were British. We were very proud to be British. So the argument that it would somehow weaken the empire. Another argument was that I had been, many years earlier, a politician. I pointed out at the time, all lawyers are politicians. The objection was that I had been an Australian politician, and the Governor-General, whether he came from Britain or not, needed to come from another country so that he would be neutral in debates about Australian interests. But this was nonsense. I was perfectly capable of doing my duty, as indeed everybody recognised once I was in the job. The King was always most gracious to me, most gracious.
And
of course my wife was a very dear friend of Queen Mary, a very dear friend.
When the Prime Minister and the Attorney General went across to Britain to, in effect, lobby quietly for your appointment, their backs being turned, the Labor cabinet appointed Dr. Evatt and Mr. McTiernan to the High Court. How do you think they're shaping up as judges?
Well, Evatt, of course, is gone now. Evatt left the court when World War II came on.
Yes.
He saw a higher duty in Australia's war effort. And of course, as I often said, Salus populi suprema lex, in time of war, all other duties must give way. So Evatt was quite right to leave the court when he did. He was a very good judge. McTiernan came out of New South Wales politics, the Lang era, you know, and that was a murky period. I was there, you know, with Scullin, with the Prime Minister. I was there when they opened the Sydney Harbour Bridge, but they pushed us into the background quite disgracefully. They had no proper respect for the Commonwealth representatives.
You were there as Governor-General?
I was Governor-General at the time, yes.
Right.
But no, it was Philip Game and Jack Lang and all these New South Wales people.
Was any of the opposition or controversy surrounding your appointment as Governor-General due to the fact that you were Jewish? You are Jewish. And would you tell us a little bit about your background as a Jew?
Well, of course, my mother had educated me in the faith, and it was my faith. And now that I'm retired, I spend a great deal of time in studying Jewish theology. But I've never been to synagogue very often. I didn't bother with the formalities. But the faith, I've been reading the book of Job. And I think I would say that the book of Job represents the farthest height in the stratosphere of religious thought that the mind of man has reached. A wonderful lesson in the purposes of the Almighty. So yes, I'm very devout in terms of faith, but to mix it with political affairs, I mean, faith is one thing and politics is another. This was the fault of that upstart Julius Stone.
Well, there was very considerable controversy that occurred. Was it during your time as Governor-General or after?
No, it was in my retirement.
In your
during
retirement.
World War II, you see, and it was. This was the point. It was the height of World War II, and here were these little fellows raising issues about Palestine. We should have been devoting all of our efforts to defeating Hitler.
This did not endear you to the Jewish community, of which you were, in some respects, a very exalted member. Were there attacks? There were attacks on you, were there not?
I think this is true. It was very divisive, and as I say, that young fellow Julius Stone attacked me personally in a quite vindictive manner. Yes, there were some very unpleasant scenes, but I was right. The model of Palestine, here we were fighting Hitler, and the model of Palestine that they were proposing would have been another version of Hitler. If there was to be a Palestine, it had to be a democracy. It had to be a place where Jews and Arabs and Christians could live together democratically. This wasn't the model those Johnnies were putting up.
One other thing that you became very involved with after your retirement from the court, I can't remember now, you will, whether it was after your time as Governor General, were the affairs of your younger brother. Your younger brother John married, here
in 1947 it's still going on, The woman is impossible, she won't go away.
Well, see if I have the story, the basic outline of the story. Your younger brother, a solicitor, met a lady several years younger
44 years younger than John.
They married, but it did not last more than a few months, the relationship.
Well, she'd only ever been a gold digger.
Yes.
A most immoral woman.
Yes.
And then the vexatiousness of her litigation, just because we turned her out of the house.
But according to one account I have read, you secretly advised your brother to convert his sole ownership of the house into a joint tenancy with you, with the express purpose of defeating any claim she might bring as the wife.
There was no secret about it. It was necessary to defeat her claim in that way. She was a most immoral woman. As I said at the time of that controversy, and there were others, she kept on at it, but at the time of that controversy I said, I consider it not only a private right, but a public duty to tell the true story of her conduct towards my brother and myself, and in doing so to make the community aware of her life and character.
And you didn't feel any constraints flowing from the fact that you were the retired Chief Justice or retired Governor General? I'm not suggesting you did, but I just want to hear from you.
No, because as I just said, it was not only my private duty to my brother, but my public responsibility to the people of Victoria to let them know what an immoral creature this person was.
But one incident, again, I'm sure this is her version of it, and I'd be interested in yours, was that in her financial need, she pawned her wedding ring, and you managed to persuade the pawnbroker to hand it over to you under some claim that it had once belonged to your mother.
It had been my mother's ring, and for that trollop to take it to the pawn shop, it was right. And of course the pawn company quite rightly handed it over to me. They never disputed my claim. They knew that I had a superior claim. And then she sued them. That was one of her pieces of litigation. The moving company, Ridgeways, that moved her out of the house, she sued them. This was what it was all about. And in the end, they had to declare her a vexatious litigant. But it still kept going because, oh dear, once she was a vexatious litigant, she couldn't institute proceedings anymore. And that should have been the end of it. But Ridgeways, I'm afraid they made a mistake. They instituted bankruptcy proceedings against her. And then she could contest those proceedings, and she did. And I must admit that for once I made an error. After John died, I applied for probate of her estate, of his estate. And that meant that she could contest my application for probate, and she did. She never let us alone for a minute. She's still at it here in 1947. She'll be at it till the day I die.
And beyond, perhaps.
And beyond.
And beyond, yes. Well, on that On that sadder note, I want to bring the matter back to say that on behalf of the Australian people, yours was an incredible life of zeal, of passion, of achievement, and public service. Controversy did not in any way dampen that assessment. I imagine your own assessment will be something higher than that.
Well, no, I'm grateful for what you say. You're very gracious, as always. But no, I would put it more simply than that. It was always a question of doing one's duty.
Sir Isaac, thank you very much.
Australian arbitration had lagged behind for years, with no affiliation for public engineers. Because they were employed by states, their logs of claims lay dead. Isaacs resented it, so he unprecedented it. And this is what he said: the implied immunity of instrumentalities gives no opportunity for social realities. The doctrine is risible, the crown's indivisible, the states are subordinate, they can't be coordinate. When power is plenary, that gives the machinery to fill up the scenery with federal greenery. The problem's constructional, the answer's deductional, the text is instructional, the states are effluxional. This new interpretation should fill us all with hope. The powers of the nation are limitless in scope. Good legalistic arguments should keep the states in line. And if that's not enough, we can always get tough with Section 109. In Peary and Macfarlane, it all worked out okay. But then Sir Owen Dixon resolved to have his say. In the Melbourne Corporation case, he threw the states a crumb. But in Sigmatic, he produced a dramatic disequilibrium. The Commonwealth's prominence and total predominance is quite categorical and simply historical. Parthenogenetical is not too poetical, it's just theoretical and exegetical. The federal polity was novel in quality, its powers inhere in it, states can't interfere in it. They can't impose acts on it or levy a tax on it. They can't be derogative of its royal prerogative. So in our federation, the rules today are these. There is no legislation unless the court should please. The Constitution's overlaid with what the court begot. But if you're perplexed, just go back to the text and overrule the lot.